Your Excellency, the Chief Justice of India, Chief Justice Lodha, Honorable Ministers and Deputy Ministers present, the Honorable Judge President of the Gauteng Division of the High Court, Mr. Justice Dunstan Mlambo, other judicial colleagues present, the Executive Director to the International Legal Foundation, Ms. Smith, and the Senior Economics Advisor for the UNDP in South Africa, Dr. Babatunde Wamilola, esteemed speakers and guests, ladies and gentlemen, I greet you. I just can't resist the temptation to single out one individual who has had quite who has made quite an invaluable contribution in the development of legal aid in South Africa, and who happened to be the Dean of the Faculty of Law at the time when I was doing my law degree. Prof. Mogoeng Mogoeng, would you just rise for people to acknowledge you for the champion that you created? I take this opportunity to congratulate Judge President Mlambo, the government of the Republic of South Africa, the International Legal Foundation, the United Nations Development Program and the United Nations Office of Drugs and Crime, and their partner institutions on a well-organized conference. I also take this opportunity to thank them for having invited me to come and speak at this conference. We gathered here to discuss one of the fundamental human rights within the criminal justice system, and that is indigent persons' access to legal aid when accused of having committed crime. And maybe due to time constraints, I should deviate a bit from my paper. It can always be circulated. I think the good starting point is to reconnect with reality. And the reality in governance circles is the following. Matters that affect the court system generally are not prioritized as much as they should. Look at the budgets, be it the budgets of the executive, the budget of parliament, and compare them to the budget of the third arm of the state, the judiciary. And that tends to explain why issues like providing meaningful legal aid to the multitudes that we know do not have the means to pay for legal representation, do not enjoy as much support and priority as they ought to. I'm happy that we have honorable ministers of justice from some of our countries present here. I think it is a good starting point to begin to talk about this issue. I've had occasion to raise it in our own country, but also went further to say, even if you look at the regional structures that have a say in matters that affect the running of the courts and whether or not the courts enjoy the kind of support that they ought to enjoy, you will find that judicial officers do not have any role to write home about to play. The SADC Tribunal, in its establishment, where judicial officers ever consulted, in reducing the role that it has to play, in ensuring that SADC is a much better place for the inhabitants of the region. Where members of the judiciary consulted, was the legal fraternity consulted. And don't you think the situation would have been much better had those who have a crucial role to play in the protection of the fundamental rights of the inhabitants of various countries and regions were afforded some space based on their experience and wisdom gathered over the years as a result of the day-to-day participation and experience of what the underprivileged are going through. Don't you think the situation would have been different? I've also had occasion to raise it at the AU level. You've got the African Court there. I doubt if, but for being appointed to the positions in the African Court, members of the judiciary and the broader legal fraternity were meaningfully consulted in relation to how best to bring about a court that would serve the best interest of the continent. Is it necessary to confine its role to the civil kind of jurisdiction that it has, or should it also be extended to criminal matters? The UN, I don't know what role the judiciary has to play there, and it's about time, I think, that we reflect on whether or not judicial officers and lawyers could bring about or make a meaningful contribution in ensuring that the many underprivileged that many of them have represented, even on a pro bono basis, that their interests are well taken care of. I think this is what needs to happen. Governments across the world need to prioritize the advancement of the rights of the vulnerable and the underprivileged. And that speaks to the creation of legal aid, state-funded legal aid. South Africa has done well, but a lot more could be done. Those of you who have been observing the developments would recall that initially its budget was lamentable. That is why you had many bills by lawyers who went out of their way to represent the underprivileged remain unpaid until those of us who were not shy to raise these issues raised them openly, and the budget started improving, the necessary institutional and operational arrangements were then in place, and Legal Aid South Africa began to perform as well as it does. We can never be heard to say we are committed to the human rights culture as governments for as long as the fundamental right to be legally represented is enjoyed even by the poor. And by legal representation, of course, it's not just a question of having a legally qualified person standing next to you. It is the quality of the legal representation that is important. You've got to make sure, as a government, as the state, that the budget is such that those who serve in these structures on a permanent basis are properly trained. There is scope for upward mobility, some career path impossibilities exists, because then they will stay. But if they are paid a pittance, you're going to have a serious problem attracting people who are sufficiently skilled to do justice to the cases of the people they represent. You're probably going to find or attract people who don't even have confidence in themselves, so much so that they will be just too happy to settle for a plea in circumstances where an accused person has a strong case. So the ability to attract properly qualified and well-skilled lawyers is one of the issues. But also the ability to train them and train them well. It's important to look into who trains these people. What does he or she have? What experience do those who train these lawyers have? And then, of course, you'll be able to retain them, as I alluded to this factor earlier on, if you pay them fairly well. But also the tariff. For those practitioners who are not in-house legal representatives employed by legal aid, the tariff determines whether or not you will continue to enjoy the services from these people and the level of seniority, the level of ability as well. Because the less you are prepared to pay, and we know there are financial constraints, determines the quality that you will be able to attract. So in a nutshell, I say, you've developed, well, the UN has developed principles that we must embrace. It is not enough to agree on what needs to be done, because we have known far too many people and governments who come with blueprints, we come with all sorts of impressive plans. I think the secret really lies in the implementation. It is the commitment to do that which you have agreed to do that matters. If the trend of having many people who are innocent, convicted, many people who are guilty of lesser offenses, convicted of more serious offenses, is to be dealt with as efficiently and effectively as it ought to be dealt with. Let me just point to something that is indirectly related to the ability of the states to provide legal aid. I think we will also have to pay serious attention to things like alternative dispute resolution. Pay attention to court-annexed mediation, because when it works, then the workload of the courts is reduced and the need to pay more money in terms of legal aid is also reduced. Consider the establishment of community courts, because if you have community courts, some of these minor offenses that clog the rolls of your lower courts, like magistrates' courts, would then be phased out. They will be dealt with by a structure like the community courts, which work well in jurisdictions like the US and elsewhere. And of course, even bearing in mind that part of the budget of legal aid also goes to some civil matters, if you restructure your small claims court more appropriately so that they sit during the day, not in the evening when it's a bit dark and dangerous, and you also make sure that you have some permanent presiding officers, as in the US, I've seen it work well there, then the resources that legal aid would at times feel constrained to assist those who are litigating in magistrates and at times even high courts with, would then be better channeled to the many needy people out there that the budget is not big enough to assist. Some people tend to make a joke of this, but I think it will also make a lot of difference. If you can restructure and resource traditional courts in any setting where traditional law applies, but in such a way that they are constitutionally compliant, again, you're reducing the workload of your mainstream courts, and their budget that is limited would then be put to better use where the need is even more dire. I'm sorry that I chose not to read my text, but I believe that you'll be able to devise some more effective strategies that could be used to make a case to the governments of different countries where legal aid is not as functional as it ought to be, or where legal aid does not exist at all, so that they can begin to appreciate this more important responsibility that rests on their shoulders. I wish you well in your deliberations. I have confidence that you will succeed. The diversity of representation that is here gives me confidence. By the end of the conference, there will be more guidelines and strategies in place to help make the world a better place for all of us to live in. Thank you so much for listening.